approaching on the Matthew Gomez case, and Judge, he's here and it's on your bond docket, but there's a BVR issue. I've talked with the state about it. Talk to them about what I think are some interesting issues, kind of by way of background in our case. And the state had previously offered, though we had not yet gotten the contract, to do a 90-day mental health PTI, which we felt was appropriate. They're going to review with the felony court to determine whether they still believe that may be appropriate, but they can't do that at the moment. They're going to have to get some feedback and find out a little bit more information about the new felony charge. I read the cases and think there's issues with both of the cases. But there is the pending BVR based on having picked up the new felony charge and need to.
Is he here?
Yes, he's here.
Come up.
Yeah, call him up.
Please.
And it's not really our issue to delve into, but I think there's issues with the way the police officers maybe made the stop in the new case. And
If he's picked up a felony offense, I'm very upset.
Okay, pause for a second, and this is a huge turning point. The defendant, already out on bond, just picked up a new felony assault on a peace officer. In legal terms, that's like showing up to court holding a lit match near a gas tank. Judges hate when defendants reoffend on bond. It signals they can't be trusted to follow court orders. But notice the defense attorney's angle coming up. They're about to challenge the stop itself as illegal. This is where things get spicy.
Understand. And
Let me express my disappointment with you, Mr. Gomez. You picked up a felony assault of a peace officer while you're on bond for this case. What happened, please?
So in the felony, the officer dispatched to a suspicious person call at a closed gas station. They observed the defendant walking around the vacant lot holding 2 glass bottles of Corona beer, indicating possible intoxication. They attempted to stop and identify the defendant, but he ignored commands and walked away towards the main road. And despite multiple warnings, he refused to comply, and he threw a glass bottle at an officer before fleeing on foot. Officers pursued the defendant for half a mile before detaining him, and while being transferred between patrol units, the defendant had already moved his hand restraints to the front of his body, and the officer attempted to reposition the restraints behind him. That's when the defendant pulled away and struck the officer's left thumb with his elbow, causing pain, redness, and tenderness. And then the defendant attempted to flee again, but was taken to the ground.
And I think there's issues with walking up and saying, we see someone and no more. Well,
It's
I know it's
not our case to litigate.
Well, I know.
All I know is that you've now picked up a felony case. Where'd you going? I got to take him.
Well, Judge, well, if we're going to be revoking him on that, then I do think it is our issue to delve into. And I think there's issues with the way he stopped. And, but if that's going to be the basis to revoke him, then this court doesn't. But the entirety of the information that the officers receive is based on what I would contend is an illegal stop. You can't just walk up and say, without more, there's no
Go
reason.
up to a guy and say, hey, let's talk.
No, that's not what they said. They said, walked up and said, show me your ID. And that's an illegal detention. That is a detention, and it's one that's unlawful under the circumstances.
I don't know.
Well, I'd like to set it for a hearing if we're going to do that.
Sure.
And he posted bond, 10,000 in the felony case. We think that's sufficient to ensure that he appears for a hearing, a formal hearing on it without needing to take him into custody. I've talked with his mother. His mother has had good contact with me throughout this process, and she'll ensure that he's here. I think if we set it for early next week, then we can delve more into the felony case and figure out if the mental health, and I think the state can get an answer about whether mental health treatment is what's appropriate. We think it's appropriate, and even if you delve into the background of our case, the allegation is that he called the police himself and said, hey, I've got traffic tickets, come arrest me, come to my home and arrest me. An allegation, well, and that he also said, and when you get here, I'd like to be in a fight. And when the cops arrive, they oblige him, they put their tasers away and fight him. And that's consensual conduct. And whether we like it or not, humans have the ability to consent in physical fights if they like in Texas. And it may not be something that we would do or agree with, but legally people are entitled to do that. And so he's not resisting arrest even in our case. So we think there's issues in our case, but we thought on the defense.
Whoa, there it is. The hammer drops. The judge is done playing nice. Notice how firm she is? This isn't just frustration. It's about precedent and public trust. If she lets one violent felony bond violator slide, it sets a dangerous message. But here's the twist. The defense is about to pull the due process card, arguing that revoking the bond without a formal evidentiary hearing violates the defendant's rights. What do you think? Should the judge have waited for a hearing first, or is she right to lock him up immediately? Let me know in the comments.
Decide that it may be more appropriate to go the Harris Center route and see if mental health PTI.
I appreciate your argument. I
Yes.
appreciate your tenacity, but I have to be fair to every single person that comes through here.
Mhm.
We have certain standards and procedures that we follow.
Sure.
When anyone picks up a felony case, especially a violent felony case, we revoke the bond and we put them in custody. We cannot continue to act in this manner. We are a civilized society and actions have consequences. I'm happy to give you a hearing, but
Yes.
no, I'm taking you into custody. You picked up a felony assault of a peace officer.
Judge, and my position respectfully is if he's entitled to, Judge, maybe before he be taken away, we finish this portion of the hearing. I think he's entitled to be president. But we think it also a part of due process that before a revocation occur, that you're entitled to both notice and an opportunity to be heard. And if they're going to be seeking to revoke his bond, then under our rules of evidence, it's very clear in Rules of Evidence 101 that a revocation, the rules of evidence apply. And everything that's gone on this morning is a proffer by the state, and I respect the proffer, but that doesn't meet the standard for the rules of evidence, and that's why.
Judge found that there was enough probable cause for a felony office to be filed against him.
Sure.
I
Well, and.
don't want to relitigate a felony case here in misdemeanor
Well,
court.
and I think
So-
that's fine. Well, but I think we're entitled to if we're going to be, and that's what the hearing would be for. But that
One of the
finding,
conditions of his bond is
Sure.
not to pick up any new cases. He's picked up a new case.
and as an evidentiary matter, there's been no presentation that he violated the conditions of bond. I know that you can look in your system and even take judicial notice of that court's finding, but that finding and pleadings that charging him with a new crime, those are not self-proving. And if they're not self-proving, then there's no actual evidence that's been presented. And we'd be entitled to ask questions to prove up, for instance, that they illegally stopped him. There's no basis for that detention. And so respectfully, I'd like to say.
Not going to relitigate the felony case. I'm not going to. You know, I respect your position, but I'm not going to.
Well,
He violated a condition of his bond,
says who?
says a felony court magistrate that put on the case again, that
He's entitled
filed
to be
it.
heard on that. And
And he did in felony court.
I don't believe that that's,
He goes in front of a magistrate. He has a defense lawyer in the magistrate, you know, when they do the magistration. So he does.
well, I think he's entitled to be heard here. If you're going to revoke his bond, I think he's entitled to be heard here. And that hasn't happened. And certainly hasn't happened in accordance with the rules of evidence.
Yeah, I would just say that, just reiterate that a district court has found probable cause in this case. To say there's no evidence that he violated condition of bond is flat out wrong, because a district court judge has found probable cause on this bond. She is picked up.
And that's not self-proving. Otherwise, in trial, they could just come in and bring in that piece of paper that finds probable cause and submit that as evidence, and they can't. That's not evidence. Those are not self-proving findings.
We're not in a trial here,
Well,
right?
Well,
You know,
no, I know it's
this is
not.
just, we're having a bond hearing.
Sure.
He's violated the condition of his bond. I understand that you don't like it. I appreciate your tenacity, but
Disagree with you.
and reasonable minds can differ, but he's picked up a felony case and there's a certain process that we follow.
Well, and so we'd like a hearing on that.
Yes, I will give you a hearing. Yes, but I'm taking him into custody because he's revoked and he's a danger to the community. I find by clear and convincing evidence, he refuses to comply with his conditions of bond. Goes with you. I'm sorry, Brian, but I mean, really,
Well,
every case, when they come in here and they pick up a new case,
I
it's
respect.
just especially a felony assault of a peace
I
officer,
understand.
you know?
I just believe that it puts the cart before the horse to make the decision to revoke based on pleadings when case law is abundantly clear that pleadings themselves are not self-proving and that the rules of evidence apply in a revocation proceeding. It's in Rule of Evidence 101, I believe. And nothing that has taken place this morning has been in accordance with the rules of evidence. I understand the court's, I understand that as a historical matter, folks come in and proffer information and I proffer information and we don't do it from an evidentiary standpoint. And that may be what the hearing would serve to accomplish. And so if the court's position is after hearing, you'll revisit the issue about whether to reach a final decision to revoke his bond or not, then we can respect that.
Sure,
The-
happy to do it.
Okay. And in the meantime, I guess I do need to request that the bond, a new bond be set in an amount that he can.
Of course, yes.
In the event that his family elects to get him out before the hearing. And in light of our
What I
discussion,
normally do in these types of cases, I always set it at 5,001. Okay? If you reach out to the family and they have a problem, then we can talk about it.
well, and I'll let the court know the bond.
Okay, pause for a second. The judge's tone here says it all. Disappointment mixed with disbelief. Picking up a felony assault on a peace officer while already out on bond? That's a major red flag. The judge knows this could destroy any chance at leniency. But here's where it gets legally tricky. Was the stop even lawful in the first place? Let's keep an eye on that.
Was set at 40,000 in the felony case and reduced to 10,000 because the family doesn't have a bunch of resources. His mother had worked to get him out on bond on that case and is going to have to do the same here, but it's really money that's coming out of the mother's pocket. And so which my whole position was get him access to resources. Now we're diminishing resources, and I respect that. I understand, but it's the mother's resources, not his. And so and the mother, and we knew that
And I hope-
this issue was coming up this morning, and he showed up. And that's part of the goal, is to ensure that he appears, and he did, and to ensure the safety of the community. And I think that part of the finding will address the hearing. But I've been,
What do you want as far as the bond?
well, I'd like it to be at 2,500. And
Say,
Stay with our rate for 5,000.
okay, when I have this kind of issue, I always split the puppy. So I'll set it at 3,750. Okay? If there's still an issue, come back and we can talk.
yes.
But there has to be a sufficient so that he understands, right?
Well, and part of the discussion was, do you really get to that point of understanding if, for instance, the allegation, even underlying our case, is you call the police and say, come arrest me, I've got warrants, supposedly telling on yourself. But when you get here, I'd like to engage in a fight. And then they come and oblige him. I don't know that that's even resisting arrest. And so,
Well, it seems like to me that he's just trying to take off the whole time. He's trying to physically, or he's evading the entire time.
No, I think it's
When he
case two.
throws something at
that's
the
the felony
officer.
charge. I'm talking about our
Oh,
underlying.
our case. Okay, I'm sorry.
And I think probable cause had been heard before I even got appointed on that case. But I think even revisiting those facts, I've talked with the state at length over the course of settings. And my position is, if you invite someone to a fight and they say, sure, we'll engage in a fight.
If you want to set this for a formal probable cause hearing on the resisting, I'm happy to do
Well,
it.
we may address it the same time we do the bond hearing on the same
Okay,
case, if
happy to
that's
do it.
appropriate.
Absolutely. I'm always willing to revisit probable cause,
Yeah,
always,
I know.
at any time, whenever. So just if you want to set it for 3 days, we can have a formal probable cause hearing on the resisting. I'm happy to do it.
It may give the state a chance to find out what felony's position would overall
Right, and
be.
that's safe, but I don't want to litigate a felony. I wouldn't think that's proper. I understand they're entitled to a hearing, but a district court judge is not probable cause on this. I'm not going to be in a position to litigate the felony down.
Right. Let's set it for 3 days,
Yes.
set it for the hearing. Let's do probable cause as well on the resisting, and then we'll come back and